Today's video is about crimes against public interest. My name is Attorney Len and I passed the 2019 bar examinations. Crimes against public interest, it can be categorized into three: falsification, counterfeiting, and forgery. If you will look closely at the crimes listed in crimes against public interest, they are not often asked in your examinations. Unlike your crimes against persons, where you have murder, homicide, physical injuries, rape, you will see them every year or every time you have an examinations. But this crimes against public interest, you will see them every now and then, but not as often as you intend it to, as you expected them to be. So, but then again, but I say, you really have to study, especially if you are preparing for the bar examinations, because you will never know what will be asked from you. There are some examiners who will ask you, number one question, what crime was committed? And you do not know what specific crime applies. You will only put there estafa, falsification, because you do not know what specific crime was committed. So it is a cardinal sin, because what is being asked from you is only a codal provision. There are no jurisprudence involved yet. There are no discussions, but what is being asked is only what specific crime was committed. So imagine if it is a number one question in your bar examination and you do not know what specific crime. So it is really, they call that a cardinal sin, because it is a basic law, basic rule, and you do not know. So this is the reason why we need to go through the crimes one by one, even if it's a boring subject, because no one knows. You will never know what will be asked from you. Okay, so let us go now to Article 161. Article 161 is about counterfeiting the Great Seal of the Government of the Philippine Island, forging the signature of the Chief Executive, or forging the stamp of the Chief Executive. So actually there are three acts that are being punished in Article 161, and that is, number one is you forge the Great Seal of the Government of the Philippines. The seal is what is in the picture. You can see that it's the seal of the government, of the Philippine government. And number two act that is being punished in Article 161 is when you forge the signature of the President. So this time the President is President Rodrigo Duterte. So if you are going to forge that, you will be liable for Article 161. And the last act that is being punished is you forge the stamp of the President. Okay. So why do you need to study Article 161? Because again, like what I said in the previous slide, if there is a question being asked from you, like what is the crime committed when a person forges the signature of the President, and you do not know Article 161, so your answer, your guess would be falsification of a public document. But that is wrong, because the specific crime here is not falsification of public document, but forgery or forging the signature of the Chief Executive. So this is the reason why I want you to study crimes against public interest, even though if it is boring. Article 162 is about using forged signature or counterfeit seal or stamp. You take note of the word using. So what are the elements? Number one is the Great Seal of the Republic of the Philippines was counterfeited, or the signature or the stamp of the chief executive was forged by another person. Number 2, the offender here has knowledge or he knew of the counterfeiting or forgery. And lastly is he used the counterfeit seal or forged signature or stamp despite having knowledge that these are all counterfeited or forgery. So that is your Article 162. Article 163 is about making and importing and uttering false coins. So it is all about the coins, like what is in the picture. You have your 5 peso coin. So what are the elements? Number 1 is there is a false or counterfeited coin. So definition of terms muna tayo. So when is a coin considered false or counterfeited according to the book? A coin is considered false or counterfeited if it is forged or if it is not authorized by the government as a legal tender. Counterfeiting, it means the imitation of a legal or genuine coin. There is counterfeiting when a spurious coin is being made. Second element is, take note of this, there are 3 important words here. The offender either made, number 1, number 2, imported, number 3, uttered such coin. So those are the acts that are being punished. So you know what made is all about. He made false coins. Or number 2, he imported false coins. And number 3 is he uttered false coins. So what is uttered? What does it mean? To utter is to pass counterfeited coins. It includes their delivery or the act of giving them away. A counterfeited coin is uttered when it is paid, when the offender is caught counting the counterfeited coins preparatory to the act of delivering them, even though the utterer may not obtain the gain he intended. So take note of the word utter. That means you want to pass the counterfeited coin to another person. And the last element is, in case of uttering such false or counterfeited coins, he connived with the counterfeiters or importers. Article 164 is about coins again, but this time it is the mutilation of coins, the importance and utterance of mutilated coins. So here in Article 164, there are 2 acts that are being punished, and that is first is the mutilating coins of the legal currency, and the other act is the importing or uttering such mutilated coin. So if it is the mutilation of the coins, there is a further requirement that there must be that intent to damage or defraud another person. So definition of terms again, what is the meaning of mutilation? Mutilation, it means to take off part of the metal either by filling it or substituting it for another metal of inferior quality. That means you want to diminish by ingenious means the metal in the coin. And another act is the importing or uttering such mutilated coin. Again, you see the word utter. Utter means you want to pass to another person a counterfeited coin. So if it is an importing or uttering such mutilated coin, there is a further requirement that there must be connivance with the mutilator or importer in case of uttering. Article 165 is the selling of false or mutilated coin without connivance. So there are 2 acts two acts are being punished in Article 165, and that is the possession alone of coin counterfeited or mutilated by another person with intention to utter the same, knowing that it is false or mutilated. So what are the requirements? What are the elements? There must be that possession, and you have that intention to utter, or meaning to pass the counterfeited coin to another person, and you have that knowledge. Take note that in the previous articles, it talks about making, importing, and uttering. Here, Article 165 talks possession. So the possession alone with that intent to utter is already punishable. Another act that is being punished in Article 165 is the actually uttering such false or mutilated coin, knowing the same to be false or mutilated. So, elements, actual uttering, and knowledge. Article 166 is about forging treasury, banknotes, or other documents payable to bearer, importing, and uttering such false or forged notes and documents. So, there are 3 acts that are being penalized under Article 166. And number 1 is forging or falsification of treasury notes or banknotes or other documents payable to bearer. Yung document to bearer, you see this in your negotiable instrument, and an example of that is your check. I want you to take a look at the word forging or falsification. Forging is committed by giving to a note, a treasury, or a banknote, or any instrument that is payable to bearer or order, the appearance of a true and genuine document. And falsification is committed by erasing, substituting, counterfeiting, or altering by any means the figures, the letters, the words, or signs contained therein. Please take note that in the previous articles, we were talking about coins. They were all about coins. The proper terminology there is counterfeited coin or mutilated coin. Here, in Article 166, the topic is all about documents. So, the proper terminology is no longer counterfeited or mutilated, but forging or falsification. So, do not make that mistake of saying a counterfeited document. That is wrong. You say that is a forged document or that is a falsified document. Another act that is being punished is importation. It's the same actually with the coin. It's importation of such false notes or of forged obligations or notes. And lastly, again, the same, uttering. Uttering means to pass the counterfeited note to another person. Is you utter such false or forged obligations or notes with the requirement that there must be a connivance with the forgers or connivance with the importers. Article 168 is about legal possession and use of false treasury or banknotes and other instruments of credit. Elements are number 1 is about the treasury notes, banknotes, or certificate or other obligation and security payable to bearer or any instrument payable to order or other documents of credit not payable to bearer. Ang haba, no? But it is all about instruments that is being forged or documents that is being forged or falsified by another person. And number 2 is the offender has knowledge or he knows that any of those instruments is forged or falsified. So take note again of the term forged or falsified. So if it is about a document or if it is about a note or if it is about an instrument, the proper terminology, again, let me emphasize, is the proper terminology is forged or falsified. And the last element is he performs any of these acts. Number 1 is the use of any such forged or falsified instruments And letter B is he possessed with that intention to use any such forged or falsified instruments. Actually, Article 168 is the same, more or less the same lang with Article 165. Article 165 talks about coins. Article 168 talks about notes. And here, take note that possession alone with that intention to use is already punishable under Article 165 and Article 168. (169) Take note, this is where your bar examination comes in. This is a favorite bar topic also. I saw this being asked in the bar examinations or any examinations for that matter. So, how forgery is committed. So, forgery is committed. I said this already. If you give it the appearance of a true and genuine document. So, there is forgery if you give a note, an instrument, a banknote, a treasury, or a bearer instrument or order instrument, that appearance of a true and genuine document. Another means of committing forgery is number 2, when you erase, when you substitute, when you counterfeit, or when you alter the figures, the letters, the words, or the sign contained therein. So, that is how forgery is committed. Memorize Article 169 asked in the bar examination. Okay, so we'll go now to Article 170, falsification of legislative documents. Number 1 element is there is a bill, resolution, or ordinance that is being enacted or approved, or it is pending approval in the Congress or any provincial board or municipal council. Number 2, here the offender, he alters the same, and when he altered the legislative document, he has no proper authority therefore, and that alteration has changed the meaning of the document. We'll go now to Article 171. 171 is a topic in the bar examination. I saw this mostly asked. It is all about falsification by public officer, by the public employee, or the notary, or our ecclesiastical minister. So what are the elements? Number 1 here is the persons liable, as already mentioned. The persons liable here are public officers, public employees, the notary public, or the ecclesiastical minister. And number 2 is that the offender, he takes advantage of his official position. And number 3 is the offender falsifies a document. So how does a public officer falsifies a document? There are at least 7 or 8 acts that are being mentioned here, and that is number 1, when you counterfeit or you imitate any handwriting, signature, or rubric. There are elements here. I will discuss this in the slides after. And number 2 is when you cause it to appear that persons have participated in any act or proceeding when they did not in fact so participate. Common to dun sa mga nagpapakasal sa City Hall. They did not appear, they did not go there, pero they will discover that they are already married. So, they made it appear like a city official na pumunta ka doon, nagpakasal ka. Number 3 is when you attribute to persons who have participated in an act or proceeding statements other than those in fact made by them. Maybe common to sa mga sa mga stenographer. Nag-testify ka, you said about something, pero the stenographer put there another else. And then you make untruthful statements in a narration of facts. When you alter true dates, take note that when you alter true dates, that date must be essential. Like for example, when you file an information and the accused there is already 19 years old, but you put there 17 years old para hindi siya makulong, meron siyang lusot. So altering true dates. And number 6 is when you make any alteration or intercalation in a genuine document which changes its meanings. Number 8 is intercalating any instrument or note relative to the issuance thereof in a protocol, registry, or official. And number 7 is when you issue in an authenticated form a document purporting to be a copy of an original document when no such original exists, or including in such a copy a statement contrary to or different from that of the genuine original. So this is your falsification committed by the public officers, public employees, notary public, or ecclesiastical minister. Okay, so still about Article 171, we said that there are 8 manners of falsifying by public officers, employees, or the notary public or the ecclesiastical minister. And number 1 there is the counterfeiting or imitating any handwriting, the signature, or rubric. So there are 2 ways of committing falsification under this topic, and that is number 1, you counterfeit, which is imitating any handwriting, signature, or rubric. And number 2 is feigning. Again, terminology, feigning. Feigning is simulating a signature, handwriting, or rubric out of one which does not in fact exist. So, example of feigning is when you draw up an open will. So, example, si notary public, he executed a will purportedly made by, for example, si Rico yan. Tapos it was requested by the parents of Rico yan and attested by other witnesses, when in fact Rico yan already died 10 years ago. So that is your counterfeiting or imitating any handwriting, signature, or rubric. Another act is the causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. Still, we are in Article 171. I am just explaining the elements or the requisites of the acts that are being punished in Article 171. So, here, the requisites are number 1, the offender caused it to appear in a document that the person or persons participated in an act or a proceeding. And number 2, such person or persons did not in fact so participated in the act or proceeding. Like I said, uso to sa mga sa City Hall, like in a wedding na may kasalan daw na naganap, pero one of the parties or the husband or the bride was not there, the groom was somewhere else, pero pinirma na lang. So, they caused it to appear that persons have participated in any act or proceeding when they did not in fact so participate. Another act is attributing to persons who have participated in any act or proceeding statement other than those in fact made by them. So, requisites, there is a person or persons who participated in an act or proceeding, and such person, he made statements in that act or proceeding. And lastly, the offender here in making a document attributed to such person or persons statements other than those in fact made by such person or persons. So again, like what I said, for example, yung mga stenographer, pag ikaw ay nag-testify and you did not say this particular statement that let us say that you sell the property to B, pero in the TSN or the transcript of stenographic notes, you will read there that you sell pala. There was already this deed of sale that was being executed between you and the alleged buyer. So that is your attributing to persons who have participated in an act or proceeding statements other than those in fact made by them. Still in Article 171, number 4 is when you make untruthful statements in a narration of facts. So here the offender makes in a document statements in a narration of facts, and he has that legal obligation to disclose the truth of the facts narrated by him, and the facts narrated by the offender are absolutely false, and the perversion of truth in the narration of facts was made with the wrongful intent of injuring a third person. There was an example given here kung you are filing your certificate of candidacy for the position of counselor, and you made it appear in your narration of facts that you are already 27 years old, when in fact you are only 21 years old or 18 years old. So that narration of fact is absolutely false. Another act is making any alteration or intercalation in a genuine document which changes its meanings. So this is your number 6. We did not already discuss number 5, which is altering the true date. So here the requisites are: there must be an alteration, which is change, or intercalation, meaning insertion, on a document, and it was made on a genuine document, and that change or insertion has changed the meaning of the document, and the change made the document speak something false. So the example given in the book of Reyes is, like for example, if you are a bar candidate and you got a grade of 73% in civil law, bagsak no, and 64% in remedial law, nako, mas lalong bagsak, mas nakakatakot, 64% in remedial law. And there was the Supreme Court employee who changed your grade. So ginawa niya from 73, he struck out the grade and made it 63. Galit na galit yata to sa yung Supreme Court employee na to. And yung remedial law, ginawa din yung 58, mas lalo kanyang pinabagsak. So that is your example of making any alteration or intercalation in a genuine document which changes its meaning. Okay, so Article 172 is falsification by private individuals and the use of falsified documents. There are 3 acts punished under Article 172, and the first act is falsification of a public document, official document, or commercial document by a private individual. Number 1 element is the offender here is a private individual, or he is a public officer or employee who did not take advantage of his official position. Number 2 is he committed any of the acts of falsification enumerated in Article 171. The falsification was committed in a public or official or commercial documents. So here, I want you to remember the difference between Article 171 and Article 172. Take note, in Article 171, the offenders there are exclusive, meaning to say only the public officers, the public officials, public officers, public employees, notary public, or ecclesiastical ministers. So they are exclusive. And here in Article 172, The offender here is any private individual. Any private individual. So that's one of the differences. Also, can Article 172 be committed by a public officer or a public employee? The answer here is yes. It can also be committed. The Article 172 can also be committed by a public officer or public employee as long as that public officer did not take advantage of his official position. Another difference is the kind of documents. So take note that there are 4 kinds of documents, and that is the public document. So when can you say that a document is public? So when there is an intervention of your notary public or na notaryuhan, then that document becomes a public document. Another kind of document is official document. Official document is a document which is issued by a public official in the exercise of the function of his office. Another is commercial document. What is a commercial document? These are the documents which are covered under the Code of Commerce. So these are your warehouse receipts, these are your bill of lading, your negotiable instruments, whether payable, whether bearer instrument or order instrument. Another act here that is being punished in Article 172 is falsification of private document by any person. Elements are the following. Number 1, the offender committed any of the acts of falsification except those in Article 171, paragraph 7. Number 2, the falsification was committed in any private document. And last element is the falsification caused damage to a third party, or at least the falsification was committed with intent to cause such damage. So one important thing to remember, if what is involved is a private document, there is a falsification of private document by any person for that matter, take note of the element of damage. That is very important. There must be damage caused to a third party, or even if there was no damage, there must be that intention to cause such damage to another person. And the last act punished under Article 172 is the use of the falsified document. Whether you use it in a judicial proceeding. So what are the elements? If you use it in a judicial proceeding, the offender knew or has knowledge that a document was falsified by another person, and that false document is embraced in Article 171 or Article 172, numbers 1 and 2. And number 3, he introduced that document in evidence in any judicial proceeding. Another kind is that use of falsified document used in any other transaction. Same elements actually, if you read them. Number 1 is that the offender knew or has knowledge that a document was falsified by another person, and that false document was embraced in Article 171 or Article 172, numbers 1 and 2, and he used such document but not in a judicial proceeding. And again, important element, it caused damage. The use alone of the false document caused damage to another, or at least it was used with intent to cause such damage. So take note of Article 172, also a bar exam area, a bar exam topic. Article 173 is about falsification of wireless message, cable message, telegraph, telephone message, and use of falsified messages. There are 3 acts that are being punished under Article 173. And that first act is, again, the term uttering. So we encountered this word again, uttering. The meaning of uttering is to pass that falsified message to another person. So when you utter fictitious wireless telegraph or telephone message, that is already punishable under Article 173. When you falsify wireless, telegraph, or telephone messages, and when you use such falsified message. So, these are the three acts punished under Article 173. Actually, there are elements here in each of the act, but I did not include already because this is not really a bar matter. I did not see them asked in any of the bar examination questions. So, para kasing obsolete na rin to when you talk about the telegraph, it talks about the telegramma before, but now, because of the technology, we already have text. We already have your email, so parang it's already became an obsolete crime. Article 174 is about false medical certificates, false certificates of merit or service, etc. So there are three persons considered liable for falsification of certificates. And number one person liable is the physician or surgeon. So I have here the picture of Bello. So if Dr. Bello, in connection with the practice of her profession, will issue a false certificate, she is liable for false medical certificates. However, that certificate must refer to the illness or injury of a person. Actually, right now, uso to no, because whenever we travel during this pandemic, we are required now to submit a health certificate. So if a particular doctor would issue a health certificate showing that you are fit to travel, you will be liable under Article 174. Another person liable for falsification of certificates is public officer. I have here the picture of the controversial Cayetano, Senator Cayetano. So if ever Senator Cayetano will issue a false certificate of merit or false certificate of service or good conduct or similar circumstances, uso din yan, like maraming nakikiusap na, sir, can you issue me a certificate of service when in fact hindi naman pala nagtrabaho sa kanya. And lastly is the private individual. There you have the very controversial Angel Locsin, red tagged as NPA member or NPA officer. So when Angel Locsin falsifies a certificate falling in the classes mentioned in numbers 1 and 2. Article 175 is about the use of the false certificates. So elements are the following: the physician or the surgeon issued a false medical certificate, or that public officer issued a false certificate of merit or service, or he issued a certificate of good conduct or similar circumstances, or that private person has falsified any of said certificates, and another person knew that that certificate was false but still he used the same, he is liable for Article 175, which is the using of false certificates. Uso to sa mga abogado, like uso to sa atin. For example, if you have a witness who cannot make it because of other reasons, tapos sasabihin na lang ng abogado, kumuha ka ng certificate, even if that lawyer knew that the client or the witness is not sick, and that client or that witness was able to get a medical certificate, false medical certificate, and this lawyer would show it or present it to the court. So counsel here, si attorney, is liable for Article 175. Article 176 is manufacturing and possession of instruments or implements for falsification. Hindi ko naman to masyadong nakita na tinanong sa bar exam, but of course, for your peace, para hindi ka masyadong kabahan, basahin natin. There are two acts punished under Article 176, and that is when you make or introduce into the Philippines any stamps, dies, marks, or other instruments or implements for counterfeiting or falsification, and second is possessing with intent to use the instruments or implements for counterfeiting or falsification made in or introduced into the Philippines by another person. So that is your Article 176. Okay, so we'll go now to Article 177, usurpation of authority or official functions. Ito, tinatanong to sa bar exams. There are two ways of committing the crime under Article 177, and first is knowingly and falsely representing oneself to be an officer, agent, or representative of any department or agency of the Philippine government or a foreign government. And second act or second offense of committing the crime under Article 177 is when the person performs any act pertaining to any person in authority or public officer of the Philippine government or of a foreign government or any agency thereof under the pretense of official possession and without being lawfully entitled to do so. So take note that the designation of the crime is usurpation of authority. Baka hindi mo kasi alam, ilagay mo estafa or ilagay mo kung ano-ano na lang, but it's usurpation of authority. Uso to sa mga nagpapanggap na mga NBI agents. Kunwari, they are NBI agents, pero if you will investigate later on, you will realize that they are only fixers. Nasa labas lang pala ng NBI nagtatrabaho. But yet, when they talk to a client, to a possible client, they will tell you that, yeah, I am working in NBI, I'm an NBI agent. Yun pala sa labas lang. So that is your usurpation of authority or usurpation of official functions, Article 177. Article 178, tinatanong din to sa bar exam, is using fictitious name and concealing true name. So you just need to know the purpose. What is the purpose? If the person uses a fictitious name. Here, the elements are the offender uses a name other than his real name. He uses that fictitious name publicly, and the purpose. So look at the purpose. The purpose of the offender is to conceal a crime, to evade the execution of a judgment, or cause damage to public interest. So that is using fictitious name. Related to the anti-alias law, that is different, that is a special penal law. And second crime in Article 178 is concealing true name. Here, in concealing true name, the offender conceals his true name and all other personal circumstances, and his only purpose is to conceal his identity. That is only to conceal his identity. Like what I told you, take note of Article 178, tinatanong din to sa bar exam. Article 179 is the illegal use of uniform or insignia. Elements are the offender, he makes use of insignia, uniform, or dress. Second is that insignia, uniform, or dress pertains to an office not held by the offender or to a class of persons of which he is not a member, and said insignia or uniform or dress is used publicly and improperly. When I was in law school, we had this classmate, whenever he goes to a class, whenever he attends the lectures, he would wear a military uniform. So all the while we were thinking that he is an officer, military officer, or connected with the AFP. Yun pala, he was a member pero na tanggal. So that is an example of your illegal use of uniform or insignia. Okay, so we are going now to Article 180, false testimony against a defendant. So, 7 crimes na lang and we are done. But before I proceed to Article 180, ano lang, break lang kasi it's been too long. Here's my tip for you. If you want to take the 2021 bar examinations, not because I want to promote my channel, no, but please watch over and over again the videos I posted here. The reason for that is I want you to I want you to be familiarized with the designation of the crimes, and I want you also to know that this crime exists. Kasi when you go to your review, especially if it's your first time to take the bar examinations, you don't have an idea of how a review works. But in review, you cannot expect the lecturer to give you a detail of each crime. Mabilisan yan. Usually the reviewer would only pick the topic that is being asked commonly in the bar examinations. May mga favorite topic lang yan, but ito yung mga maliliit like yung false certificates, dinadaanan na lang yan. They don't discuss that in detail. So in the secret in passing the bar examination is you know your law. You know your basic law. Do not mind your jurisprudence. Do not mind the discussions, because the jurisprudence and the discussions, the jurisprudence, they always change, but your law is the same. And if ever you will be confronted with a facts, we have the different perception of facts. It will be a mistake of fact on your part if you will not able to digest, if you are not able to process the facts. Pero if you will write there a wrong law, you have a different perception of a law, that is a cardinal sin. Masyadong malaking kasalanan yan, because you are supposed to study your basic law. So go back always to the basics. You go back to your codal, know your codal, just know your law. Isulat mo lang during your examinations, isulat mo lang yung law, isulat mo yung elements, and even if your answer is wrong, but since the teacher, your professor, was able to read that you know your law, but you have that different perception of the facts, you will still get a point. The examiner will still give you a credit for that. So go back to your law. Always go back to your codal. You read your law, know your law. That is the secret in passing the bar examinations. Also, let me just remind you that when you take your bar examination, especially next year, no, in 2021, if you are a first timer, you will learn that during the bar month, the November, you will realize that you have very limited amount of time for preparing, especially during the bar month, the November. If your first subject is political law and labor law, during the bar month, take note that you only have 3 days to study political law and 2 days to study labor law. In this case, criminal law, it is partnered with commercial law. Sa commercial law, you have at least 11 laws. There are 11 laws or more than that. Marami yan. So, pag nag-aral ka dyan, sobrang dami. So, you only have 3 days to study that. And then, 2 days for criminal law. Not enough for you. So, at least be familiarized para lang you have an idea. You already have an idea. Familiarize. This is the reason why I want you to watch my videos again and again. Kung ma-memorize nyo nga kahit yung mga fonts na ginagamit ko, better. Kasi, this is the process of repetition. It is the process of repetition actually in the bar exam. So there. So we'll go now to Article 180, which is false testimony against a defendant. Here, the elements are: there is a criminal proceeding and that offender testifies falsely under oath against the defendant therein, and the offender who gives false testimony knows that it is false. And here, the defendant against whom the false testimony is given was acquitted or convicted in a final judgment. False testimony against a defendant. Article 181 is false testimony favorable to the defendant. Take note, in Article 180, it is against the defendant. In Article 181, it is favorable to the defendant. So, here a person gives false testimony, and that false testimony is in favor of the defendant, and the case involved is not civil case, but a criminal case. Article 182 is false testimony in civil cases. Elements: first, the testimony must be given in a civil case. The testimony must relate to the issues presented in said case, and that the testimony must be false, and that the false testimony must be given by the defendant knowing the same to be false, and the testimony must be malicious and given with an intent to affect the issues presented in said case. So, that's false testimony in civil cases. Wala naman masyadong tinatanong dito. Article 183 is your favorite bar topic. That is what you always hear: perjury. So, false testimony in other cases and perjury in solemn affirmation. So, there are two ways to commit perjury, and the first is you falsely testify under oath. And the other way of committing perjury is when you make a false affidavit. So, yung essence ng perjury is you are under oath. Elements: the accused here, he made a statement under oath or executed an affidavit. An affidavit is also under oath upon a material matter. Second, the statement or affidavit was made before a competent officer authorized to receive and administer oath. And in that statement or affidavit, the accused made a willful and deliberate assertion of a falsehood. And the last is the sworn statement or affidavit containing the falsity as required by law. Just differentiate this with Article 180, which is the false testimony in favor of the or against a defendant. So, there kasi, in Article 180, there is that requirement that the defendant there was convicted or acquitted in a final judgment. Here in perjury, you just made a statement under oath, and by making such a statement, you are already liable for perjury. Article 184 is offering false testimony in evidence. What are the elements? Number one is the offender offered in evidence a false testimony or a false witness, and he knew that the witness or the testimony was false, yet he made an offer in a judicial proceeding or official proceeding. So that is offering false testimony in evidence. Article 185 is about machinations in public auction. Take note of the designation. The term used is machinations in public auctions. So this is about bidding public auction. So there are two acts punished under Article 185, and the first act is when a person solicits any gift or promise as a consideration for refraining from taking part in any public auction. So, consummation, that this crime is consummated by mere solicitation. So, mere solicitation alone will make you liable for Article 185. So, what are the elements? Number one is there is a public auction. The accused here solicited any gift or promise from any of the bidders, and such gift or promise was the consideration for his refraining from taking part in that public auction. And the purpose or the intention of the accused is to cause the reduction of the price of the thing auctioned. So, dito, hindi siya mag-a-attend. So, para hindi ako mag-attend, kayo na lang, bayaran nyo ako. This is your first act of machinations in public auctions. Second is attempting to cause bidders to stay away from an auction by threats, gifts, promises, or any other artifice. Ito baliktad. This is the opposite of the number one, because here, ikaw naman ang magsasabing wag kayong mag-attend. Ako lang ang mag-a-attend, kayo, wag na kayong pumunta, wag na kayong makisali. So the elements here are, again, there must be a public auction. The accused attempted to cause the bidders to stay away from that public auction, and he did it by threats, by giving them gifts, promises, or any other artifice. And the purpose is the same with number 4, which is he has that intention to cause the reduction of the price of that thing auction. So, just take note, if the facts would say there is a public auction, take note immediately of machinations in public auctions. That is your Article 185. Article 186 is about trade, restraint of trade, monopolies and combinations in restraint of trade. There are 3 acts punished as monopolies and combinations in restraint of trade, and number 1 is if there is that combination to prevent free competition in the market. So elements are when you enter into any contract or agreement, or you take part in any conspiracy or combination in the form of a trust or otherwise, and in restraint of trade or commerce, or to prevent by artificial means free competition in the market. Because what is the rule? The rule is it should not be monopoly but free competition. Another act punished as monopolies and combinations in restraint of trade is monopoly to restrain free competition in the market. Monopolizing any merchandise or object of trade or commerce, combining with any other person or persons to monopolize said merchandise or object in order to alter the prices thereof by spreading false rumors or making use of any other artifice to restrain free competition in the market. And the last act is manufacturer, producer, or processor or importer combining, conspiring, or agreeing with any person to make transactions prejudicial to lawful commerce or to increase the market price of merchandise. So, who are the persons liable? Those are the manufacturer, the producer, the processor, the importer of any merchandise or object of commerce. And what is the crime committed? That is combining, conspiring, agreeing with any person, and the purpose is to make transaction that is prejudicial to lawful commerce or to increase the market price of any merchandise or object of commerce manufactured, produced, processed, assembled, or imported into the Philippines. So take note that the designation of the crime is monopolies and combination in restraint of trade. Maybe an example of this is during this pandemic, we had this issue dun sa face mask na minsan the prices are absurd. So this is what Article 186 wants to penalize or wants to prohibit. And also during this online classes, 'di ba, yung presyo ng mga laptops biglang nagtaasan. So, that is also your example of Article 186. Okay, so we are now with Article 187, the last article under crimes against public interest. So, Article 187 is about importation and disposition of falsely marked articles or merchandise made of gold, silver, or other precious metals or their alloys. Here in Article 187, the articles or merchandise involved are those articles or merchandise made of gold, the silver, other precious metals, or their alloys. And here the elements are: the offender, he imports, sells, or disposes any of those articles or merchandise. Second, the stamps, the brands, or the makers of those articles or merchandise fails to indicate the actual fineness or the quality of said metals or alloys. And number 3, the offender has knowledge or he knows that the stamps, the brands, or marks fail to indicate the actual fineness or quality of the metal or alloy. So this is your crimes against public interest. I did not include already the remaining articles because those are about unfair competition. Tinatanong yan sa commercial law, your intellectual property code. That is a topic. So thank you very much, and please, if you can tell your classmates about me, please share my video, like, and subscribe. Thank you.